Hello and welcome to the webinar Risk, Resilience and Reputation, Managing Internal Investigations in Italy. Over the last 2 decades, there have been a growing focus on white-collar criminal prosecutions in Italy, especially in the years following to the 2008 financial crisis. Governments, regulators and the media have all scrutinized corporate behavior. Today, in 2021, I believe everyone watching this webinar can agree that organizations across the world have had to manage a new set of unique working challenges. Working practices have shifted, corporate priorities have changed, and resources have been reduced and reallocated. Yet, when investigations are deemed necessary, companies still need to conduct them in a sensitive, appropriate, and defensible and timely manner. Our session today will outline the investigations landscape in Italy. We will provide GCs and risk compliance professionals with guidance on the practical steps that can be taken to mitigate, manage, overcome the different stages of an investigation, right from the initial complaint to the final outcome. My name is Haveen and I'm one of the editors here at the Legal 500. And before I introduce our esteemed panelists, I would first like to introduce our moderator, Professor Enrico Maria Mancuso, Equity Partner and Head of White Collar Defense and Investigations Practice at Pedersoli Studio Legally. Enrico provides judicial and extrajudicial assistance in white collar and corporate crime matters. He also is an expert on compliance matters and has a long-standing experience in conducting internal investigations in Italy and across multiple jurisdictions. Whilst leading the white-collar defense and investigations practice at his firm, he also finds the time to share his specialized knowledge with students at one of the leading universities in Italy, where he is actually a professor of criminal procedure law. Thank you, Enrico. You can say a quick wave to the camera, just so brilliant. Now, I would like to warmly welcome our expert panel, who as industry leaders in Italy and beyond will be sharing their thoughts and experiences today. So in no particular order, we have Lina Vitolo, General Counsel of Iliad Italia Group. For those who do not know, Iliad is the 4th largest mobile operator in Italy, and Lina has been managing its legal operations since 2007. She has played a key role in driving a number of business projects. Prior to that, she's worked as an EU regulatory and competition lawyer at a range of top-tier international law firms. She's also served as General Counsel for Italy, Spain, and Portugal at UPS Europe in Belgium. In addition, she's worked at the Dan1 Group in France as Senior Compliance Manager and Competition Counsel. In 2016, she actually got her PhD in EU Competition Law at Bocconi University in Milan. Welcome, Lina. Feel free to give a big wave to the camera.
Thank you. Hi, everyone. Thanks, Arvin. Thanks, Enrico.
It's great to have you here. Our next panelist, I've actually had the pleasure to meet when I traveled to Milan, the fashion capital of the world, of course. Sara Chitiro has been with the iconic fashion label Trussardi for almost 2 decades. Joining in 2001, she now leads legal operations as Group General Counsel. Her main responsibilities include legal affairs, corporate governance, intellectual property, dispute resolution, and compliance. That's just to name a few. She's appeared several times on our very own GC Power List, and in 2019 was actually awarded In-House Counsel of the Year in the Fashion, Luxury and Design category. Hello, Sara.
Hello, Haveen. Hello, everyone. Nice to be here.
Last but not least, we have Laura Falconi, Senior Legal Director, Medical Devices Group, Mid-Size Markets from Johnson & Johnson, a very topical area to be working in, especially in today's current climate. Laura has had over 20 years experience as a business attorney, having worked in both in-house practice and private practice roles. She has a profound interest for the healthcare sector, regulated environments, business dynamics, ethical leadership, and team management. Her experience includes commercial, contract, and consumer law, along with a host of other legal areas. Thank you, Laura. Thanks for being here.
Thanks to you and welcome everybody. Happy to join this interesting webinar discussion.
Great. Now that the formal introductions are out of the way, we would like to thank our sponsors, Pedisoli Studio Legally, for supporting this webinar. Now, before I hand over the reins to Enrico, we just want to let the audience know that if you have any questions, you should be able to type them in real time in our question box. That way our panelists and moderator will be able to view them as they roll in. Now, with all of that being said, I will hand over things to our moderator for today. Thank you, Enrico.
Thank you, Arvin, and welcome everyone to our webinar. Today's webinar has a strange title, I would say: Risk, Resilience, and Reputation. So 3 aspects that we will try to focus on together. My role will be the one of setting the scene and then trying to facilitate a dialogue among the experts that today are here with us. And I am very happy. So thank you, Lina. Thank you, Sara. Thank you, Laura, for having agreed to share your experience and your thoughts on this topic. Just let me share some slides I prepared for this occasion. So when dealing with internal investigation, I would say that the exercise that the corporation might do can be interpreted easily as one of the many ways by which the company pursued the goal of improvement. Improvement through research, through risk assessment. And when an issue presents itself, of course, Arvin has already highlighted the way business has changed over the last months, let's say a couple of years. It is necessary to find out what happened, what did not happen, what did not work, and what can be improved within the organization. Of course, the issue that might give rise to an investigation can be very different, can have different origins, nature, and might trigger different consequences. So we will try to point out the main of those. Of course, internal investigation might be considered a multifaceted reality. This phenomenon that has its origins in the US and in the UK, it's becoming increasingly popular in Italy, but I will also add other continental regimes. Just let me quote the case that happened a couple of years ago in Germany. We all know that case as the Jones Day case. So a leading case, I would say, of the Constitutional Court of Germany that makes pair with the recent proposal to reform the corporate criminal law in Germany. This proposal includes a new statute, a new regulation for internal investigation. So continental regimes now find themselves maybe not ready to face all the challenges that this internal investigation might trigger. Internal investigation is a term that can refer to activities carried out, of course, in very different factual contexts. We will talk about whistleblowers report, but also we will talk about the internal investigation triggered by an initiative of the judicial authority. And we will try to look at the difference that might be seen between internal investigation, pure internal investigation, and defensive investigations. Equally relevant, of course, is the potential different regulation that this kind of investigation might find. I will try to focus on this topic during our conversation. When speaking about internal investigation, I would say Italian Parliament has not yet given a legislative framework for that, even if in our criminal procedure code we have a statute for defensive investigations. To try to sum up, I would say that internal investigation give great opportunities, but also might give rise to considerable risks. Let's try to understand what's that about. As regards to the opportunities, of course, An internal investigation might help companies intercepting an indication of risk and, of course, preventing consequences for the company. So this is the case of a pure compliance exercise or of an internal audit exercise that focus on specific themes. But sometimes the internal investigation is triggered by an event. In this case, of course, an internal investigation exercise is necessary to try to reconstruct what happened, identifying potential responsibles and areas of improvement. In any case, the compliance exercise is aimed at reinforcing the existing measures, the existing policies and procedures that might avoid in the future eventual breach. But internal investigation also are useful to demonstrate also to prosecutors and authorities the company's reactivity and the effort to improve the organization continuously. I would say that sometimes this kind of exercise is also paired with self-disclosure. So sometimes cooperating with the judicial authorities is the scope of the investigation. I am aware that by telling this, I am touching a very delicate point, especially in Italy, where there is no obligation to self-disclose offenses. But filing the results of an investigation to the authorities, suggesting also investigative leads to a prosecution, and offering cooperation might result in, I wouldn't say a leniency, but in a good result, in a good outcome of the procedure itself, if need be. But I also mentioned the fact that an internal investigation might trigger risks or maybe challenges. I mean that sometimes the exercise carried out with the internal investigation might be a bit disruptive or might have a disruptive effect on the organization. And sometimes we have seen that in the past, it results in an activity that is a bit hindered by the members of the organizations. And of course, not everyone is happy about receiving an audit or receiving an internal investigation, especially when this is followed by, for example, a disciplinary procedure against employees. There are, of course, other risks or challenges that should be properly assessed during an investigation. I would mention, for example, the difficulties in involving external professionals without jeopardizing the legal privilege. We will talk about that. And also the communication challenges within and outside the company. The careful communication matter is something that is now having a continuous, let's say, result from the authorities, and we see that there is a constant attention of that by the prosecutors. But then I would like to switch to the discussion and to involve the panelists. When determining the scope of the investigation, I would say that the internal investigation is a result of internal controls, processes, product audits, or some inconsistencies that are reported by the statutory auditors or by the vigilance body, the Organismo di Vigilanza in Italian. So I would like to ask Sara, this is of course true for those companies who operate with a large network. Your iconic company that was mentioned by Arvin is a leading company in the luxury industry. You have suppliers from very different countries, and the challenges are many. So what is the correct balance between these controls, preventive, subsequent controls, the efficiency of the organization? How would you say that these factors reflect also on determining the scope of the investigation?
Thank you, Enrico. You have actually hinted some very delicate points in starting an internal investigation. And actually, it is quite true that the way you just draw the scope of your investigation, it's sort of designing the scheme on which then the investigation goes on. And if you start it off quite wrongly, it then may determine and hinder the entire result of it. So it's quite important that from the offset, you've got your ideas just clearly enough in order to just collect the correct information and interview the correct people and make sure that the exact informations are circulated in the most appropriate way. So you're right when you're underlying the fact that it's quite sensitive and that it has to be taken quite seriously, because it's not just the interviews, it's not just the gathering of data, but it's how you just put them all into the framework and make the framework work. Designing the scope of the investigation isn't easy, and it's quite easy to be taken aback sometimes and not do things properly, because too narrow a scope can imply missing some important informations along the way, or maybe giving the idea, especially if you're working with a judiciary, as you mentioned before, that you are somehow willing not to unveil some information. But on the other side, if you do not design it properly and you design it as a too broad a scope, then you give way to endless investigations and sometimes spend so much money and end up with nothing in return. So you've got to find the right balance here. Balance which is not that easy to find. That's why the onset of the investigation is perhaps one of the most crucial points when you start to look into matters that are irregular at some point. There is no golden rule as to what to do in order to set up a proper scope of your investigation, and the scope must always be tailor-made. Speaking about a fashion house is somehow quite a joke in its own way, but the initial scope must necessarily be based as a first thing, and we can say this for everyone, I think, based on the information available. But you have to be ready to be flexible and adjust your scope according to what you find out along the way. There are a few ideas that I can give as a hint for everyone, or which can form at least the basis for some further thinking about how to organize the scope of your investigation. And foremost thing is one question that everyone has to ask when you start investigating something, which is whether the allegation that you're facing is a compliance issue which is worth investigating. Because sometimes you receive hints, notes, or sometimes, as we are going to see when we're talking later on about whistleblowing, sometimes you are confronted not with facts, but with opinions. So you have to be just wise enough to single out what are the facts which are worth investigating, what are the opinions which you have to leave along the way, or which are considered as important but not so important. So you've got to point out the facts most of all, and how these facts are affecting compliance. For example, just to give a very practical point of view, it's quite basic, but just to explain, some 18 months ago, we had a theft in our cellars. And was it a mere theft? We wondered. So we just needed to report it to the police officers, or did we suspect that someone from another company plundered a copyright model to pass it on to a competitor, for example? So are we going to set off here for an investigation, or is it just petty crime that I have to report to police officers, and that's it. So this is pretty much the the discussion I was just making an example of, but just to give a hint about what to actually have in mind when you start off with your investigation. There are other issues, for example, that you are to be faced with. For example, if you have got or not a protocol for investigations. Sometimes it is worth spending some time before actually getting into very worse things to actually have a sort of protocol, maybe an easy one, but it helps you gather some information and have some thoughts already set out and ready to apply to different aspects. For example, how to interview individuals should you need interviews, or how to secure confidentiality to all the documentation that you gather along the way, how you select documents which you can use in respect to the applicable legislation. For example, we'll see later on privacy issues that may arise out of an investigation, how you circulate reports, which is also quite important. Do you have to have them written? Are they too delicate, so you need to present them orally? Maybe it depends on the very situation. That's why I was telling you that it must be actually be quite tailored, unless you enter into bigger mistakes. Then another sensitive issue, for example, is what's your budget? Because we must not hide it. Investigations can be costly. It's not a matter just of direct costs, for example, for external counsels when you need them. And certainly when we'll talk about legal privilege, probably we will need one. But actually indirect costs as well. Sometimes the board is not always quite aware of how much the time of an internal counsel costs in selecting information, for example, going through hundreds of emails or documentation to pick out the relevant ones and just leave behind the non-relevant ones. So this balance between direct and indirect costs must also be considered, and this must be placed in respect of how big the threat is to that we are actually facing to go to in investigation. So basically, in general terms, fact assessments, identification of law provisions that may be violated, or company policies as well, because we are not just talking, of course, about breach of legislation, but maybe just breach of internal company policies as well, which are relevant in respect to, for example, as you were mentioning, employment matters, and assessment of relevant evidence. So these are three basic pillars on which personally I draw my attention to whenever I try to draw the scope of the investigation. Of course, there is always the risk of missing something and not focusing immediately on the exact matter. So we should always find a balance between something which is quite strict as to how to design the scope, but leaving somehow a way out for broadening your scope whenever you find out that evidence that you have gathered along the way suggests that maybe there should be something more behind it than what you have initially thought there was. So the task of drawing the perimeter of an investigation is all but an easy one. So we have to take proper attention to it. And lastly, as a hint, I would like to leave to all the attendees here is the also the definition of the jurisdiction, which is quite important and relevant because it sometimes helps us also visualize what could be the problems in terms of enforcements, for example, of our findings, but also how we treat privacy matters, how we treat also legal privilege, which we said there are some countries, for example, South Korea is one of them, but Hong Kong also, where in-house counsels have a limited legal privilege, and this could help dealing with some sort of investigations. But we know that sometimes in other countries, well, certainly in the EU is not the case. We don't have it. So this helps us understand when we have to involve our external counsels, and how easy it is to start with them or just to introduce them in a second instance, for example, and go along the way as internal counsels. All these aspects are quite relevant, quite important, and they may have an impact. So if we do not devote enough time to design it before starting an investigation, we could really end up having a search that's worth very little, if nothing at all, and spending money and time over something that is not effective at all.
Thank you, Sarah. This is an impressive analysis, and I just want to underline a couple of elements that might be also useful for the next discussion. And mainly the idea that nowadays companies, complex corporations, multinational corporations cannot live anymore without a protocol for investigation. So guidelines, procedures, outlining at least how to intervene, who is going to decide on whether and when to intervene, and I would say, and I would add, how to combine and compose the investigation team. Because that's, of course, a very sensitive matter, very sensitive issues to be addressed case by case. So there is no rule on the basis of the characteristics of the whistleblower report or the activity that you have to carry out and the result you want to pursue at the end of the day and the usability you want to have of the results of the investigation. Missing something in that respect is never a problem, because you can just try to amend or define in a different way, of course, the structure of the investigation. But that's very interesting. And I would say that this is paired with the idea of understanding which jurisdictions might be eventually involved. And we have seen that mainly in the past with the relevance that some internal investigation might have for US purposes, FCPA-wise, I would say, but recently also for UK Bribery Act purposes. And we will see what's going to happen in the UK, as my understanding is that the law commissioners are now working on a reform of the corporate criminal law, trying to understand if the liability of the corporations might be regulated. And of course, we know that in this environment, the internal investigations, FDA, NPA, are connected to the prosecution. And so it's going to be very interesting to understand what kind of choices might be the outcome of that exercise. You have mentioned, Sarah, also the idea that the allegations might or should be severely scrutinized because they could be only opinions. In this respect, of course, many internal investigations originate from reports of whistleblowers, some irregularities, wrongdoings, and they come from members of the organization, which is most of them, I would say, or from individuals who assess or say they have enough information to describe a phenomena that relates to the company. In this respect, I would like to ask to Lina to give us an idea. Let me add that the company reaction is very important to preserve at least another point, which is not only the need for understanding what happened, really, scrutinizing the report, but also acting as a deterrent for wrongdoers for the future in case there is a breach. So Lina, in your experience, what are the safest and also the most effective, I would say, ways to manage this whistleblowing? And can you give also some examples on that?
Yeah, thank you for the question. It's of course the discussion is very interesting, and there are some points I would like to share which resonates with both some elements that Sarah and you mentioned before. So I think that, as you said, Enrico, the role of whistleblower is two-sided. So you have from one side the importance as a source of information. So it might be an employee, it might be a third party, but also the importance of let's say preserve this role is connected with the effect to deter, let's say, the wrongdoers. No, this is something that we learn from the experience from antitrust authorities, where you have the leniency programs and the whistleblowing is used also, let's say, has a deterrent effect. So I think that this is coming together with the value of our company and the building of the culture of the company, and this resonates with what you were saying before, Enrico, the improvement. So where do we improve the culture of a company to preserve this role from wrongdoers? I think that it's very important to work on some specific values to preserve this role of whistleblowers. First of all, I would say communication and transparency. Then we have, I think, simplicity, trust, and cooperation. I will, let's say, explain a bit better what this value means for me and for my experience in the other companies. So first of all, it's very important, I think, to inform the company and the third parties on what is the existence, first of all, of a whistleblowing procedure, so the right, but also the obligation to report certain wrongdoings. And this comes together with clarify the extra scope of the whistleblowing procedure, because sometimes this is also let's say misunderstood by people. We receive, for example, sometimes individual HR complaints, which of course are not in the scope of whistleblowing. So it's very important for me to make it clear, inform the people, and help to create an environment where the whistleblower feels safe and comfortable to come and report some issue. And of course, there are trainings, newsletter, you can invent events. We had, for example, a number of compliance days where there is, let's say, information about the procedure. And it is also important to have encourage and enhance open discussions and, let's say, speaking up culture in the company, so that everyone is really let's say engaged to collaborate with the company. And it needs also to be let's say very clear, and this is going where Sarah was saying before, on the process. So what is the process, how the investigation is dealt with, what's the composition of the team. So this is going also together with transparency. For me, I think it's very important that there is motivation for any decision, that the whistleblower is informed and timely. So timely response to whistleblowing is also important, because you show that there is this importance of reporting. Of course, it is important to check where it is worth investigating, and so this is not only based on the seriousness of the allegation, which can be a big thing, but also on the credibility of the request or of the facts that are submitted by the whistleblower. So we don't have to stop where opinions are brought about, but it's very important to gather data from different sources. So check really the credibility of the request. Then, of course, it's very important to have a very simple whistleblowing tool, ethic lines, whatever you call it, and this comes to the value of simplicity I was saying before. It has to be multilingual if there is an international company, because even if everyone speaks English, they might be deterred from let's say, apply for the whistleblowing procedure in another language which is not their own. of course, there should be, I think, the possibility to interact with the whistleblower, which is important, then to ask questions and also, let's say, counter check the facts, whether those are only opinions or not. And of course, you need to provide the anonymity option, which is now mandatory, but since a few years ago was something that I think it's really important. So when it comes to trust, also I think there are two main values that the company should preserve, and they should be in the culture of the company, which are professionalism and collegiality. So professionalism in the conducting of the investigation, collegiality in the decision-making process. So the team members, now you were mentioning before how the investigation team should be composed. I think that there should be neutral and independent members, also to show that, let's say, the judgment, the decision making is independent. There should be the assessment of fact should be as more objective as possible. And another very important thing, in my opinion, is to allow a wide range of corrective and remedial action. No? You should not stop on disciplinary action, but also considering some measures which are going to the root causes of the violation, which can be improving policy or introducing new policies or processes. And this is also something that goes together with the concept of improvement that Enrico was mentioning before. Then when it comes to cooperation, we mentioned already the necessary option of submitting an anonymous complaint, but it's very important. This is to protect the whistleblowers from retaliation. Of course, when it comes to retaliation, everyone thinks about firing the person or let's say sanctions, etc. But there is a gray area of intimidation actions. This is also very important to take into account. Because any intimidation or retaliation has a chilling effect of whistleblower also for the future. So it's very important that it is given the right importance. Then another issue, and this might be element of discussion for later, is whether whether it is opportune to consider rewarding the whistleblowers. From one side, you need to make sure that the reward is appropriate and that is not conflicting with a good faith approach, because of course you can reward only whistleblowers which reported something in a good faith state. And here I would like just to make an example which comes from the public sector, but in the US, the Security and Exchange Commission provide rewards in a range of 10 to 30% of the fines which comes from the civil enforcement action coming from the tip of the whistleblowers. And of course, I think this is something that in our jurisdictions, in European jurisdiction, is a bit exceeding what we are used to, but still I think it's something to be considered.
Thank you, Lina. It's crystal clear, your idea, and I think that there are some elements that, again, have to be considered by ourselves. I have just read a question from the public. I just want to pose it to you because it matches with what you have said. How do you, as a company, create a culture of compliance in that sense? How do you make it easier for a potential employee to blow the whistle on an issue without feeling guilty or concerned about their job security? You were mentioning the risk of retaliation. So yes, it is compulsory. We know that also in the private sector now it's an obligation. So if you have an organizational model, you have to put in place some measures that allow you to avoid, so to preserve anonymity and to avoid any potential retaliation. But how do you as a company pursue this effect?
Yeah, I think it's very, very important, and it should be crystal clear in the internal investigation policy. So first of all, adopt an internal investigation policy where you make crystal clear as a procedure, also binding for HR, legal and compliance, not to retaliate against the whistleblower. So the protection for whistleblower should be crystal clear. When it comes to culture, I think that the option of the speaking up environment, which I was referring before, is not only providing the tool for anonymity, but also promoting a discussion with managers, with the direct reports, or with compliance. So having really people which are available to hear others. So try to promote really this kind of open discussion and information sharing, and also, as I said before, doing a lot of training or information through newsletters, to events, and so promoting a lot this kind of open discussion, even making cases, so providing some examples. And it is important also to let's say put in the right light the effect of a report, because of course the company, in particular the very, very large company, legal compliance, they cannot be aware of what is happening in some other departments, some other countries. Sometimes legal is not centralized, so it's not present in every premises. So it's really important that the information is brought to the attention of the company to avoid a number of bad effects for the company itself, but also for the persons and the managers.
Thank you, Lina. Thank you very much. Now, moving to another point, let's try to focus on the way the investigation should be conducted. So when an investigation is needed, and we will see what the red flags might be to trigger that, in-house lawyers of multinational companies often find themselves in a difficult position, I would say, because they have to interact with the local management, but also with the internal control bodies, so statutory auditor, supervisory bodies, and with the investigative team that has been set up by headquarters or locally, I would say. So furthermore, there are companies that more often need to have an external consultant, that could be a lawyer or could be another complex organization. We will speak about the forensic review, which is now a common practice. And given such a complex web, of course, ensuring an open dialogue and a clear strategy is essential. So, Laura, I would kindly ask to tell us what can be done to facilitate this dialogue internally, and what are the challenges that could be posed by the fact that multiple jurisdictions are involved. You work in a US multinational that is now, present in every single part, in every single nation of the world. So what are the challenges that are posed by this complexity?
Thank you, Enrico. Yes, first of all, I would just highlight what you just mentioned, that indeed being involved in this internal investigation is really, in a way, a traumatic event for in-house lawyers. So I would say first from a very practical point of view, because normally we know that we have very packed agenda already with lots of meetings, a lot of priorities, business priorities and all of that. And of course, when these investigations knock on your door, and again, the sources can be really varied. They can be internal, external. It can be also media. It can be competitors. You said. So it's something that I mean, you need very often to prioritize and to put on top of your agenda. And of course, this create so also very practical, let's say, issues to really find the time to really focus, understand, of course, how serious this allegation can be, who you should involve, when, how, etc. And then, as you said, well, of course, I am a part of a very big American multinational, so we have, of course, a very, very robust, I would say, protocol on how to escalate and who to involve. We normally have this escalation policy where we need to report let's say, to what we call a triage committee. So it is an internal independent body that basically, based on some criteria, classifies this reporting based on the nature of the reporting. So if it is more financial, if it is more labor, if it is more privacy, compliance, etc. And also based on an assessment on the risk level, so how serious it is. And then, let's say, once it goes up to the triage committee, it gets back with let's say, an answer indicating the person that should be involved on that specific piece of investigation. So in some cases, it is handled at local level by the competent functions. In other cases, you need to involve external investigators. And so let's say that the in-house lawyer in all this complex environment indeed has multiple stakeholders that she needs to speak with. And of course, we need to be very careful in what information to share with whom at what time. So it's a very complex decision matrix, I would say, because of course, depending whether you are talking to your management, local management, whether you are talking to the assigned investigation team, whether you're talking to external counsel, whether you're talking to internal vigilance body, you need to really frame well the information that you need to disclose. And so let's say, probably being a part of an American multinational, we also have, I would say, we really measure very carefully the communication, because as far as possible, and now I'm referring, of course, to the more sensitive investigation, you want to protect legal privilege. And already the colleagues mentioned that unfortunately in Italy we are not protected as in-house lawyers by legal privilege. And particularly now in a remote setting, this is a very, very hot potato that we need to manage very, very carefully, I would say. So I think that normally the approach that we take, let's say, is that as long as the investigation is not complete and the findings have not been fully investigated, the allegations, have not been fully investigated, and you have made an assessment on the findings that you may have found, we keep the communication really as limited as possible. So we really try to communicate only with external counsel, with our, let's say, as I said, investigative team, so we really try to share with local management just some regular updates, but more on the status, the progress status of the investigation. And only when the investigation is final, is closed, then we share normally with the top management a report, let's say, with the results of the investigation. Also because at that moment, of course, you may need to involve them also in some follow-up actions for which, of course, they need to be informed. But certainly, it's I think a very delicate role. So, and I think it's where the in-house lawyer can really play a very, very important role in also, I mean, in protecting the company, but also, as Lina was mentioning before, in trying to learn from this process and ensure that whatever the outcome is, you really build on lessons learned, you really build on trying to improve as much as possible, and really foster an environment that encourages people to bring on the table any potential issues as early as possible. And this is something that a message that as legal or compliance we try to convey very often to our people.
Thank you, Laura. And again, it was very important to stress the idea of the lesson learned, I think. There is a question from one of the attendees that would pose to you immediately in this respect. He says, when starting an investigation, how do you get the right people in the room? And what's the best way to conduct forensic analysis? As regards to the first part of the question, maybe the lesson learned that you were referring to is some part of the answer, but I leave you the floor to give us some ideas on this point.
Yes, how to identify the best people to bring on in the room. So as I said, I think maybe it's we should split, because on one hand, we have to identify the person that will materially, let's say, carry out the investigation, so interview, etc. As I said, we have already our triage committee that in a way filters and guides us, but this is also something that we influence, meaning that of course we also we know the company very well, we know the people, we know the business, so we also try to really also in the reporting categorize all the issues, compact them, and maybe also offer already a proposed action plan, saying so I would like on this issue to hear this list of people, I would like for this other issue maybe to collect this list of documents. So I think it's really something, as also Sarah was saying, it's not unfortunately a one-size-fits-all solution, because you really need to understand the facts, to see the allegation, and you need to know very well the organization and the business, because you need to know exactly also within the company who may be the person that is in the best position to clarify a certain issue, to provide, to describe a certain process, etc. So I would say, and then of course, as you also said, in some more sensitive issues, maybe it's important besides documents, policies, etc., to also have a look at emails or WhatsApp messages, etc. So you need a forensic review. So in that case, of course, we have some companies that we partner with that carry out this process. So let's say this is from the side of who needs to carry out and help and support investigation. Then on the other side, you also need to identify the person who may be targeted for the investigation. So and this normally is you may already receive this list from the whistleblower, from the investigation, etc. In some cases, you need, again, based on your knowledge of the company, of the organization, also try to enlarge And even there, it's not normally that you listen and you interview only the persons who may be the target of the allegation, but you normally want to listen also to his, her team, to his, her manager, to people that this person has connected with in carrying out the situation which is under review. And so, unfortunately, in some cases, this broadens up quite a lot. So you end up with quite a long list of people. But I think, again, in a way, this is healthy because, of course, you do not want to base your conclusions, your findings on just a partial, superficial review. I mean, once you dig, you want to get to the root cause, to the bottom line, and listen as many people as possible.
Thank you, Lara. Very interesting. Sarah, do you want to add a few words, a couple of minutes on the legal privilege issue? We were trying to assess whether this balance between the internal team and the external counsels could be somehow balanced by the in-house lawyers. What do you think about that?
Yeah, well, this is quite a crucial point, I think, in the discussion, since I think Laura and Lina, as well as myself, we are sometimes, or maybe often, or maybe even always involved in cases of investigations, especially as far as well, crimes are allegedly being committed. So I think that this point is really very important. And unfortunately, as far as I know, well, there has been a change in the past weeks in respect to the Spanish legislation in this respect that has granted. We'll see to what extent, because I think that it's becoming effective in July, I think. So we are going to see the effects later on, probably next year. But as far as the EU is concerned, there is no legal privilege surrounding the activities of in-house counsels. So this is quite tricky, because we must always keep this in mind whenever we start investigations, and we are already aware that something big is going on. I think especially about future cases brought in front of courts, for example. And this is quite critical, because we need to have assured that every kind of conversation, especially written, is somehow covered by legal privilege. And it's not that easy. And especially if we think about jurisdictions, as we were mentioning before, some jurisdictions allow us as in-house counsels more room to move, actually. And as far as we keep something in mind, for example, we have to take some precautions whenever we write also internally that we are giving a legal advice. For example, I mentioned Korea. This is one of the cases. If we mention that we are actually giving a legal advice, even within the company, then this is covered by a legal privilege. Otherwise, if it's just seen as a sort of, well, let's say business advice, this is not covered by legal privilege. So this is quite tricky. This is the reason why it's always easy to make mistakes under this very point of view. So we have to be really cautious every time we do exchange documents and reports, especially. That's why I was mentioning at the beginning that we have to decide if some reports have to be given orally only, because we do know that we have a limited legal privilege. So if we have to report to our board, for example, and we have some sensitive issues to report, sometimes it would be better to actually just report them orally. So our role within the companies is quite tricky because we have to make sure that we make the important decision under this perspective as well.
Thank you, Sarah. I totally understand how delicate is your role, and I've seen that in a couple of investigations. Sometimes the in-house counsels asks us to share documents not using email, for example.
Indeed.
This is the point, indeed, you know. And so we are.
Which now, this COVID is even more difficult. So it's an additional hurdle that we need to consider.
Yes, of course. So let's move to a couple of specific issues, of course, sensitive issues, because we are dealing with this investigation matter. And I would say that the need to carry out this investigation necessarily entails the processing of personal data of employees. So the forensic review we were referring to, or the WhatsApp messages scan, it's another one. And in this regard, of course, the set of rules that are outlined by the EU and the Italian legislation on the right to privacy change significantly, depending, of course, on the type of internal investigation you're carrying out. Because if you are carrying out an investigation triggered by a criminal procedure and you're doing a defensive activity, it's a chapter. Otherwise, it's a bit different. And the challenge, of course, is to strike a balance between the right of privacy and of confidentiality of the subjects that are involved in the investigation, and of course the right of the company to gather the elements that might be necessary to defend itself. And of course, in this respect, companies like Iliad, Lina, that are operating in technology, media, and intercom industry are often involved also in a different role, I would say, because you provide services and infrastructures also that are functional to the processing of personal data, and in particular for data retention purposes. So we are speaking about a very delicate topic. We know what was the outcome of the first directive on data retention. So consequently, of course, you can give us a unique perspective on this topic. So can you give us an overview of the main obligations in this regard, and what are the most important policies that you think should be implemented in this respect?
Yeah, I think that actually in the telecommunication sector, there's a, let's say, good example of massive management of data, of course, because there's a number of users, which is very, very high, and the personal data are, of course, of different nature. So this gives me opportunity to discuss two issues. One is, as you said, Enrico, data retention issues, but also security concerns. I think it's very important, and this is both for internal investigation and for the supporting of investigation by authorities, to make have a special attention to the management, the correct management of data, for three main reasons. The first one is data preservation. So you need to preserve data because they are needed to conduct investigation to support the authority. Then also, as you said, also privacy and protection of the personal data of employees, whistleblowers, third parties, and also, of course, protecting the business secrets, because sometimes also you gather information and there's a number of secrets or very confidential information about the company and its activities. So when it comes to data preservation, just to make an example for internal investigation, in our sector, you can have serial frauds by users, which can reroute traffic. So when you need to, let's say, make an internal investigation, you need to comply with a number of binding rules, and especially there's a specific rule from the Italian Privacy Code, which provides that you are allowed to make an exception to the 6 months retention policy for traffic data, in case of defense of your rights. So this would be the case. It is very, very important then to alert the data holders of the need to preserve the data, so to retain the data exceeding the period which is imposed by law by sending a preservation notice. So this is very important. And of course, you have the importance of securing that the system is doing it by itself when you, let's say, put the order in. So it's very important and linked to the security measures. When it comes to investigation by agencies, so by authorities, you know that the telecommunication providers have a special duty to make available to any judicial authority for tax and criminal violation all data regarding users. So this is provided by the electronic communication code, because there's, let's say, a kind of public service. So the communication provider is in charge of a public service. And this is not only related to the lawful interception, but it's also related to traffic data. And when it comes to traffic data, there are two very important elements to consider. One is, again, the data retention, and the second is security, to come to my first opening of this intervention. So data retention is strictly, let's say, regulated by the law, but you have some exceptions. So you have the period of retention is extended to 72 months, normally it's 12 or 24 months, if you need to provide information to the authority for anti-terrorism purpose. So it's very, very important, of course, to preserve such data, to be able to cooperate with the investigation by the authorities. And how you do preserve is not only by, as I said before, having the system which allow you to the specific retention, but also to comply with a number of security measures for the data traffic. And again, here there is a specific legislation by our privacy authority, which is dating back from 2008. So before, let's say, what is now the Article 32 of the GDPR, which provides accountability when it comes to security measures. So it says that you need to decide what are the appropriate technical measures for the organization, taking into account the level of security and the risk that you are facing. But again, there's a specific rule which impose to telecom operator to enforce a number of security measures for such data, which is of course useful also for the preservation of data. And you don't only have the policy or data encryption or log control, but you also have vulnerability tests on systems, so the obligation to have this kind of tests regularly on the system. You have, this is very peculiar to telecommunication, the strong authentication obligation for those who's access to the data, which includes a biometrical check when it comes to traffic data. So this is just to say that it is really important for us to make sure that all data, massive data, are available and retained for the mandatory retention period, but also are secured in a way that allow to let them available for any request of the authority.
And I would add that many of these cybersecurity measures have now become a golden standard also when dealing with the smart working or home working environment. Of course, the pandemic has changed the world, and we have seen that. And I have seen many companies trying to implement the measures you were mentioning, even if they are not involved in the specific market sector industry you were referring to. So this new normal, we call it, after the pandemic, has brought, of course, I would say, an organizational challenge specifically related to the smart working. And I just want to linger a bit on this because I just was wondering, how can this affect and eventually increase the risk of illicit behaviors in the context of an organization or a company's capacity to acknowledge the higher risk Laura, do you want to give us an idea on that? How can, of course, this can be reflected also within the normal and internal controls that we are used to do, and how can this, as a consequence, be seen, investigated in internal investigation?
Well, I think I would make a very, again, practical introduction that probably what this remote working has taken away from our daily routine is really the close touch with the organization, with the people, with the business, because really, I mean, being on site in the business, in the premises, you really get, in a way, the vibes. You get the rumors. You get really a more tangible sense of what is going on, and I think this kind of connection, unfortunately, in a remote setting is lost. So although of course we have tried to set up alternatives to stay close with the management, with the business, etc., I think this is indeed the challenge. And then for the rest, if we go back to an investigation environment, well, I think this ties well with what you mentioned before, also about careful communication, because this is really something, for example, where we have been focusing a lot in terms of training, because we have seen so many cases, and I mean, also if you open newspapers or read on the internet, you see that normally most of the evidence that is used in criminal investigation comes from wiretapped conversations, from exchange of emails, messages, etc. Sometimes also taken a little bit out of context. And so one in the training sessions, one of the messages that we also reinforce, and that I think it's even now more valid, is really, I always tell people in the audience in the trainings, you always need to speak and behave as if someone is listening to you. I mean, just take it for granted. I mean, do not mind if or if not you are wiretapped or the people you're speaking with. I mean, you always need to speak carefully, because you do not really want what is maybe a just normal interaction, business discussion, be perceived as you know, that something is strange is going on. So you really need to be careful, and this also is I think linked to the reputational aspect, because also in some investigation, you know, even jokes or jargons that is used in between salespeople can really be taken out of context and used against you, and this really affects a lot the reputation. So I always, you know, remind our people, when you enter into a business discussion, just be aware of what you say, that you say it nicely, that you say it, you put the discussion into a context, that you really, again, if someone is listening to you, he or she can understand what you're talking about, and doesn't have doubt or concerns. And I think this is really very important. Also because, and also, you know, when you launch new projects, maybe, I don't know, health economic studies, clinical studies, just always remember what is the outcome that we want to achieve, what is the reason why we are entering into this new study. It's I think very critical. It was critical before, and I think more so when in this context. And then also maybe another point is about the interviews, because I must say that prior to COVID, we used to do all interviews in person. So this was one of, let's say, the safety measures in a way that we were taking. I mean, first also, again, to create a connection with the person, of course, because you also want to see the body language, you want to see how comfortable the conversation goes, no? So you want to get also the body signals. But also, of course, to be sure that we were also protected from legal perspective. Now, of course, with COVID, with remote working, having in-person interviews has not become possible in most of the cases. So we needed to use Zoom or other tools. And we know very well that this can be, I mean, that everyone can register what is the discussion. So it's not certainly the best setting, but at the same time, you always need to balance the interest and the priorities, and in a way that they need to investigate and to again to also in a 231 law perspective here in Italy, that of course you need to really prove that that you vigilate, and that you of course take measures where appropriate is a must, so is a priority, but certainly, let's say, it's not the ideal setting, in my opinion.
I totally agree, and let me add that, of course, the issue you were assessing concerning careful communication, the risk is even higher when dealing with the pharma companies or the life science industry, because you usually have to speak with parties that are public officials. So in that case, the areas of risk that might be triggered are really higher. And as regards, of course, to the potential dialogue, of course, the remote working has somehow destroyed the body language and all the elements that we were used to look at. Sarah, I don't know if you want to add something on this, and specifically what are the mistakes that should be avoided, or the risks that should be assessed when carrying out in an internal investigation. This was one of the first points I was trying to figure out.
Well, actually, just to be quite quick, because I see we are running out of time, so I'll try to stick to a couple of minutes. But actually, one of the things that I thought about when I was listening to what Laura was saying a couple of minutes ago was that during the pandemic like this, it's not just, as she clearly and correctly pointed out, the secrecy of the interviews that they are being carried out, which is quite crucial whenever you conduct an interview one-to-one, for example, and so you've just got to make sure that some sort of privacy is or confidentiality is preserved, even in conducting video conferences, for example, because apart from registrating, so maybe you've got people who are interviewed who are recording with cell phones or anything like that, but maybe we are not aware, being in a separate environment, but there are other people listening, for example, their own counsels that we are not aware of, and so we have to be quite careful in this respect on how we conduct the interviews. So, for example, we are not suggesting answers, and we are asking things quite clearly and straightforwardly, for example. And this is something that's quite crucial. And another one, it's another issue which is quite important here, is how you preserve the information and the data, especially when you're working from home. Because if you are just dealing with the systems that you've got in-house or at your corporate offices, it's probably easier. And on the other side, when you're working from home, this can be sometimes be crucial because, of course, there are so many things that may be, stored in different places other than your own servers and so on. Maybe things that are deleted more easily. So it's also a matter of how you preserve your evidence in case you just need them, especially when everything is electronic. And this is something that has to be addressed to quite seriously. Otherwise, we risk of missing some very important pieces of evidence, which may be of use maybe later on.
Thank you, Sarah. This allows me to step to the last point of our discussion. So we are really running out of time. So I just want to make a last roundtable and ask you, what are the next steps or the steps that a company might decide to move after an investigation has been concluded, having in mind that the title of our webinar today is also referred to resilience and reputation, so the reputational risk. There was a question that was addressing also to this topic. So what are the challenges in this respect? What precautions needs to be taken? And what mistakes should be avoided during an investigation in order to reinforce compliance and plan the next steps? Maybe we can start with Lina, then Sarah, and then Laura.
Yes, I think it's very important during the investigation, as we said already, so preserve the evidence. So make sure that everyone is alerted when it is known that an investigation is starting to, let's say, preserve the evidence. It's very important also to gather all facts from differentiated sources, so not stop from the first source where we have the submission or the first information. The facts should be assessed objectively, and so this comes again with the composition of the team of the investigation. So make sure that there's no bias or there is no conflict of interest from the team members to assess. Of course, it's very important also to let's say separate the team members for the investigation from the, let's say, decision authority or decision entity, which can be the board of directors or ethical committee, so that this entity is separate from the one that is conducting the investigation. So to make sure, of course, that the decision is impartial. And when it comes to the decision making, it's very important to have in mind, as you said before, the reputation of the company. So taking into account that any action that is going to be decided, whether it's a disciplinary action or it's a report to the police or whatever, it is linked to the let's say public availability also of the information within the company and externally. So really make sure that the data and the fact gathering is counterproofed and can also, of course, be defended in case of contestation.
Sarah.
Yes, I think that one of the important things that come, of course, after an investigation is also a critical issue of the remediation. So we found out that something has gone wrong. We found the evidence, we found who's guilty, who's not. But then the next step should and must be what can the organization do to prevent these things from happening again? because of course no investigation of any sort will have, except of course if you have to defend yourself in front of a court, for example, but this is something different. But as far as in-house counsels, or so we should ask ourselves, well, we actually found ourselves faced with something that has gone wrong. What can we do to let our company benefit from what we discovered, to avoid things from happening again? So this is also quite important. Just as important as how you conduct your investigation is how you proceed further on. So you've got to amend processes and procedures, maybe, lift barriers to authorization processes, or maybe design new processes because you just found out that something that has gone on in your organization is not covered by any process. So you need to build another one. And this is crucial as well, as just as important as discovering what happened as how you remedied it.
Laura.
Yeah, no, absolutely. I'm very much aligned with Sara and Lina. Maybe one additional point about remediation is that I think the input for while of course from a technical perspective you may have several functional leaders involved in redesigning, amending, upgrading your processes and all of that. But I really think it is important that management is accountable for these changes in the process, that they are aware, that they are on board, and that they really make what we call the tone at the top, so that really you have this top-down approach in the organization that involves everyone. So this is also important for the culture of the organization.
Thank you, Laura. I think that our time has now finished, and I want to thank you because, of course, your contribution to this panel and to this webinar has been impressive and of an incredible level. So thank you very much. Havin, I leave you the floor for the last words.
Thank you, Enrico, for facilitating such an insightful discussion. We definitely covered some really interesting points, and I'm sure all the viewers found it really insightful. A special thank you also to Lina, Sara, and Laura for taking time out of your incredibly busy schedules to share your experiences today. I would just like to remind everyone that this is being filmed and you can find it on our on-demand service. So I know that we'll all be racing to take more notes and you can do that in your free time. All right, I'd just like to thank everyone again and enjoy the rest of your afternoon.